Good day, everyone. My name is Dan Sampaio, and I'm delighted to welcome you to today's Mondaq Webinar in association with eLeague. Today, I'm joined by the brilliant lawyer, Mr. Gönenç Gürkaynak. Gönenç is a founding partner of eLeague Gürkaynak Attorneys at Law, a preeminent and leading law firm in Istanbul, Turkey. Gönenç will today be focusing on merger control trends in Turkish competition law. Now, before we get started, here's how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and Gönenç will address them as we go through the presentation. Thank you very much, and I would like to now hand you over to Mr. Gönenç Gürkaynak.
Hello, everyone. I hope that I'm going to give you an hour worth of interesting and new developments. So the point of the exercise today, obviously, is not to repeat the static and more rigid parts of the Turkish merger control rules that you can understand by simply reading the secondary legislation. But rather to give you a flavor of new developments and an understanding of where new case law is taking the trends in Turkish competition law. Needless to say, in order to be able to do that, we're going to also provide some groundwork on what the legislative landscape looks like. But ultimately, our goal is going to be to discuss as many cases and new developments as possible. With that, if we could move to the next slide, let me start to give you the landscape. Now, there's the legislation. The seminal legislation is the law numbered 4054 on the protection of competition in Turkey. And then there are lots of communiques and regulations and other secondary legislation. The particularly relevant secondary legislation in our case is the communique numbered 2010/4, which suggests that this is a legislation of 2010, although there have been some changes in it afterwards. The governing body, the independent authority that is enforcing the law and the secondary legislation is the Turkish Competition Authority, the competent organ of which is the Turkish Competition Board. So the Turkish Competition Board takes the final decisions on matters of competition law in Turkey, and the Turkish Competition Authority, together with its legal services division and the case handlers and very many other bureaucrats and public servants, they are doing their best to enforce competition law in Turkey. When I say they're doing their best, I'm also opining on the fact that the Turkish Competition Authority is one of the administrative authorities in Turkey that has its heart in the right place, in the sense that they are going after a technical enforcement of competition law matters. It doesn't suggest that whatever they do is correct, but at least their first prerogative is to make sure that competition law is penetrated technically in the way it is governed in the law. Next slide, please. We have a dual threshold in our legislation. I'm not going to bore you with the details of this dual threshold, but you need to know two things when checking the Turkish jurisdiction. One, that this is a turnover-based threshold, and two, that the thresholds are quite low in Turkey. As you can see, for example, and these are alternative, the A and B are alternative to each other. A, which is the more frequently functioning of the two, A is suggesting that if the aggregate Turkish turnover of the transaction parties were to exceed about 12.5 million euros, and if the Turkish turnover of at least two of the transaction parties were to exceed approximately 3.7 million euros, then this is a notifiable transaction. I'm not going to go into the details, but I'd like to leave you with a mental impression that the thresholds are quite low. So these thresholds would catch very many transactions and as we will discuss in the future, some transactions that have a very remote nexus with the Turkish jurisdiction, as in the case of joint ventures that are actually going to be functional and operational elsewhere in the world, and only the joint venture partners happen to have an operation in Turkey that exceeds the threshold, but the joint venture has nothing to do with Turkey. Still, this becomes notifiable in Turkey, and the Turkish Competition Authority and the board has been quite keen on that point. So consistently, they have come up with that kind of jurisprudence. Next slide, please. Now, if you were to want to understand how active the authority is, we can give you a first half of 2020 flavor to you. There have been 107 merger control notifications in 6 months, in the first 6 months of 2020. Mind you, the first 6 months of 2020 was also hindered quite significantly from mid-March to June, especially due to COVID-19 developments, which we will also discuss the effects of the COVID-19 developments in merger control in Turkey. But even with that particular impact, the number of merger control notifications in Turkey were 107 merger control notifications made to the authority in 6 months. So you can assume that about 250 notifications are being made to the Turkish Competition Authority, which is no surprise because our law firm alone does about 95 to 100 merger control notifications in a given year. 70 of these are qualified as acquisitions, 33 of these are qualified as joint ventures, and mergers are 4 of them. The reason why I'm giving you this breakdown is because when we say mergers in Turkish merger control, what we mean is that very rare and elusive creature of true breed mergers where 2 entities come together and formulate a third entity, or there is an actual amalgamation of a sort that I will explain in the future. But in most instances, either what is notified is joint ventures, and 33 of these joint ventures have been notified, and a lot of them were joint ventures that were not going to be directly or indirectly operational in Turkey, but because of the parties that were bringing in the joint venture, this was notified, and then a vast majority of them were acquisitions. Next slide, please. So, as I promised, this is the definition of a merger. Only 4 of them have come along. Either 2 or more independent undertakings would amalgamate into a new undertaking by terminating their legal entities, which is very, very rare. I'll give you an example of that, a recent example of that. Or an undertaking is merged into another undertaking entirely, with one of the undertakings surviving as an entity. There's the third type as well, but I'm not going to take too much of your time on this. Next slide, please. So in Nippon Sanyo, which is February 2020, a matter that is handled by our law firm, the board analyzed the merger of 2 undertakings, Nippon Shokubai and Sanyo Chemical Industries, and the board concluded that the transaction concerned merger of equals, since Sanyo and Nippon were contemplating to merge and operate as one single entity. Now, you might ask, why does it matter? Why don't you just call it a concentration and be done with it? It is at the end of the day a concentrated transaction, and it will have to be checked under the merger control thresholds. The trick is that the thresholds applicable to mergers are not exactly the same as the thresholds applicable to acquisitions. I'm not going to get into the details of this because it might be confusing, and it's not really the new trends happening in Turkey, whereas I wanted to give you an account of new groundbreaking things that are happening in Turkey. But ultimately, you need to know that mergers are handled somewhat differently than acquisitions in Turkey in terms of the application of the thresholds. So if something is characterized by us or other local counsel, for that matter, as a reverse triangular merger, is this seen as an acquisition or really as a merger, is a question, the answer of which is germane to the analysis of whether the transaction is notifiable or not. Next slide, please. So the definition of acquisition, therefore, also comes into gameplay. I'm going to just inform you on this slide that a full function joint venture is deemed as an acquisition for the purposes of the application of merger control thresholds as well. Next slide, please. I would report that for colleagues who are used to the definition of control in the EU and the US, for that matter, the definition of control is not significantly different. Actually, it is not at all different than that under the Turkish legislation. But one thing that you need to know is that there have been a lot of transactions where the Turkish Competition Authority has taken a different position as compared to what the European Union has said about the situation of control. So in some instances where the transaction has been seen as concentrated, the Turkish Competition Authority has not seen a change in control. In some other instances, other files, there was a significant debate as to whether there is joint control or no control under Turkish law. While all of our definitions, de jure control, de facto control, the exercise of decisive influence, the strategic business decision matter, these are all the same in Turkish law. There have been some nuances and differences that mandated us as a law firm to give an advice that says this wouldn't be seen exactly the same way it has been seen elsewhere in the world. Next slide, please. I'm not going into the details of, what is negative control, what is a strategic decision, and what have you, because, as I said, we have embarked on a journey of giving more of, what is cutting edge, what is happening in Turkey. So the textbook explanations of contexts or issues we're skipping. In Marubeni Temsa file, there was an acquisition of sole control over Temsa by Marubeni, which used to be jointly controlled by Marubeni and Sabancı. So Marubeni was basically switching a joint control to sole control. And the Turkish Competition Authority has confirmed that this is the case because Sabancı did not have the ability to create a deadlock. So the authority first excluded the possibility of a negative control. And on top of that, Sabancı did not have any veto rights on the strategic business decisions of Temsa either. So in June 2019, the acquisition of sole control over Temsa by Marubeni was seen as a switch from joint control to sole control on account of these two prongs. In TFS Mitsui, the establishment of a joint venture was being discussed. Toyota Motor Corporation and its subsidiary Toyota Financial Services Corporation was forming this joint venture with Mitsui & Co. Limited. Both parents were entitled to appoint senior executives. This was seen by the Turkish Competition Authority. Major decisions of the Greenfield JV were going to be subject to both parents' approval, and both parties had the opportunity to create a deadlock by not consenting to significant strategic matters. So the Turkish Competition Authority saw a joint venture here. Now, you might feel that it seems this is going to be a Greenfield joint venture. You were saying Greenfield joint venture, both verbally you said it, and also in your slides it says Greenfield joint venture. So why is this notifiable anyway? The Greenfield joint venture, sure enough, didn't have any turnover in Turkey. The response to it is the same analysis that I have provided to you, which is that a joint venture does not have to have an operation in Turkey to be notifiable in Turkey. It is deemed as establishing a structural link between two parties, and if those two parties have an operation in Turkey that exceeds the alternative thresholds, especially the thresholds under paragraph A that I have presented to you, then that joint venture is going to be notifiable. Hence, the statistics that I've shared with you 70 acquisitions are notified, 33 joint ventures are notified, and 4 mergers are notified in only 6 months in the slowest period of time, where 3 months of that time period was taken by the first wave, first shock of COVID. So joint venture notifications are very, very frequent in Turkey, and the precedents relating to joint ventures are quite consistent. Next slide, please. So from a joint venture analysis perspective, a full function joint venture has the same prongs of a full function joint venture in the EU: the existence of joint control, the joint venture being an independent economic entity, and the joint venture being established on a long-lasting basis is needed for it to be seen with the previous vocabulary as a concentrated joint venture, or with the newer vocabulary. When I say newer, it's vocabulary of 13 years, but I've been practicing for 23 years, so it's a newer era vocabulary. It is a full function joint venture, so it's exactly the same as it would be seen in the EU. Next slide, please. The full functionality analysis has constantly focused on particular 4 prongs by the Turkish Competition Authority. They also reserve a heading in reasoned decisions to these. Does this organism have sufficient resources to operate independently? Does it have activities that go beyond one specific function for the parents? Does it have independence from the parents in sale and purchase activities? Is its operations on a long-lasting basis? Now, you might say that I'm just repeating things that are well known in jurisprudence elsewhere as well. So how is this interesting, or how is this belonging to new trends? Where it becomes interesting is that the Turkish Competition Authority has time and again characterized certain joint ventures differently from the way the EU Commission has characterized it. So the Turkish Competition Authority puts more emphasis on finding these prongs and very concretely seeing them. So there's less of presumptive work going on, and there's more of positive duty of putting forward the existence of these through advocacy. Next slide, please. One such example is DSM Evonik. The transaction concerned the formation of a joint venture between DSM and Evonik. The board indicated that although the joint venture will have its own production plant, this is why we chose the example, because they actually formed as non-full function a joint venture that was commanding a production plant in Turkey. This plant will be used only by the parent companies, and the JV will commercialize the products produced only by the parent companies. Therefore, it cannot be evaluated as an independent economic entity. The board concluded that the joint venture will not be a full function joint venture, that this cannot be evaluated under merger control regime, so it should be considered as a horizontal cooperation agreement, which is what you do not want if you have taken the matter to the Turkish Competition Authority as a merger control matter. The board evaluated the JV as a restrictive agreement under Article 4 and conducted an individual exemption analysis under Article 5. So basically, they have done an analysis of whether individual exemption would be granted to this transaction. On the other hand, the European Commission examined this transaction exactly with the same dynamics, and they examined it under the simplified merger review procedure and approved the creation of a joint venture and concluded that the proposed transaction would raise no competition concerns from a merger control perspective. So while the rules are exactly the same, and a textbook advice by a Turkish local council could be that whatever the EU Commission says should go also in Turkey, this is not exactly the case, and there are certain emphasis that are put by the Turkish Competition Authority's case handlers on independence, on the prongs of full functionality, as I have explained. Next slide, please. This one I'm not going to take too much of your time with because I'm cognizant of the time, and I want to make sure that questions can be handled as well. And there's nothing new or interesting in this particular slide. I have added it just to give better context when I'm circulating the slides. Next slide, please. Ancillary restraints is also an important issue in Turkey. You do not have to argue the ancillary restraints. There is no positive duty to get an approval for your ancillary restraints of a merger control matter. But the flip side of the coin is that if you have obtained an approval for your transaction, it does not automatically mean that any restraint in the transaction documents are therefore vetted as ancillary restraints. So the Turkish Competition Authority also has the luxury of providing a green light to the substance of the matter without getting into legal advice work on the restraints that are bringing about the transaction or protecting the transaction. So the ancillary nature of a restraint is seen in the geographic scope, the subject matter, the duration, and the nature of the restraint, whether it is directly related and necessary to the concentration at hand, whether it is only restrictive on the parties, whether it is proportionate with the goals of bringing about the transaction. Could this transaction have been formulated even in the absence of this restraint, or is it bringing about restraints that are so directly necessary and relevant to the bringing about of the transaction? So the concentration could not have happened if these restraints were not there. In terms of duration, the Turkish Competition Authority is quite sensitive. If you wanted to exceed a 5 years duration as a categoric idea, you may want to seek counsel and make sure that this would fly because of the specific dynamics of the transaction at hand, because anything that exceeds the duration of 5 years would attract quite a bit of scrutiny. Again, if there is a joint control being brought about, any ancillary restraint that lasts even after the separation of the joint control would attract attention, and it may not be seen as ancillary to the transaction that is being presented for approval. Next slide, please. One example that we would share here is the Garanti Bank BBVA transaction. There was a non-compete obligation on both parties directly related to the transaction. Doğuş Holding, the owner of Garanti Bank, had significant know-how regarding Turkish banking system and Garanti Bank and Garanti Bank's key customers. The non-compete obligation was restricted to former activities of Garanti Bank and restricted to Turkey and the parties. The duration was less than 3 years, and this was allowed. In a sector like banking, where customer know-how is extremely important, and you could sell a bank and actually come up with yet another bank that is directly competing with the bank if you have the financial depth and power to do so. The ancillary nature of the transaction was recognized. Next slide, please. The fact that I'm giving you a 2015 example is also testament to the fact that in recent years, ancillary restraints discussions aren't happening as much in notifications, because this is now in the self-assessment zone. So most counsel, including us, would prefer that unless there is something specifically requiring legal certainty, a borderline handling in the transaction documents, one would be well advised not to get into this discussion in the merger control notification, because the Turkish Competition Authority does not need to opine on it. And if you can provide a legal advice providing legal certainty for the parties anyway, the parties would be free to proceed with the matter. So what happens once you notify? There's a phase 1 review. Either in phase 1, the Turkish Competition Authority would approve, or they would open a full-fledged investigation, which is a phase 2 in Turkey. Phase 2s are becoming a bit more commonplace, but statistically they're still a small fragment of the entirety of reviews in Turkey. And the phase 1 reviews are getting a little longer, especially in the COVID-19 times, where the case handlers are finding it more difficult to talk to each other, and there is more of a shuffle in case teams while the review is going, because there may be sickness in the team, and there may be particular precautions that are taken. Someone may be quarantined and all that. So we are seeing that the regular review duration of the Turkish Competition Authority is extended, not quite dramatically, but it is extended. So we're seeing more of notifications that have been decided on between 45 to 60 calendar days, as opposed to between 30 to 45 calendar days from the original date of filing, and more notifications with more than one round of questions by the Turkish Competition Authority, which seems to be owed also to the need to distribute the workload in these extraordinary times. Next slide, please. So an example to the phase 2 review where the authority has ultimately approved the transaction. So I wanted to include this example because I wanted to make everyone attending understand that a phase 2 does not necessarily mean that there's going to be a rejection or a conditional approval, or that you have to engage in commitments work immediately. Sometimes a phase 2 is there to enable a closer look into the matter, and to enable a better examination of the file. And it is very important that the local council is in contact with the case handlers to understand what type of a phase 2 this is. So is it that the matter at hand is seen in such a dead end that before rejecting it, a phase 2 is being offered as mandated by the High State Court in Turkey, which is the highest administrative court in the administrative line, and it has opined in the past, well, it has given judgments in the past that has said the Turkish Competition Authority cannot reject a transaction without launching a phase 2 into it? Or is it because more homework was needed? There were a lot of entries into the file, and the timeline is quite cramped in phase 1, so the case handlers needed more time, and so they have proceeded into a phase 2. So in the example I brought to you, Gönenç Kimya and Fragar matter, the board evaluated that the transaction would not give rise to anti-competitive effects due to the following factors after doing a phase 2 review on each of them. In phase 2, the board has found that there is a dynamic nature of the market. The retail level is quite homogeneous. There is a lack of or very limited entry barriers. The existence of the switching case between local and global suppliers is quite significant, and there is countervailing buyer power too. So on these findings, the Turkish Competition Authority has approved the transaction. Typically, if there is a high HHI index, or if there is a high market share post-transaction, the Turkish Competition Authority might tend to take the transaction into a phase 2, and in that case, it is not very easy to engage in commitment negotiations. You can provide a commitment in phase 1 as well, but the Turkish Competition Authority typically wouldn't engage in a back and forth negotiation in phase 1, because at that point the case handlers wouldn't know if the board is going to support the idea of a phase 2 anyway. So are they negotiating something without a mandate from the board? Whereas if they were to bring the matter to the board and say, we think a phase 2 is mandated, and if the board were to ratify this, then they can engage freely with the transaction parties as to what kind of a commitment would solve the matter, or if the parties prefer to defend the matter, as it has been the case in Gönenç Kimya, or another matter was our Boyner YKM transaction. where the biggest non-food retail chain in Turkey, the biggest department store chain, was buying the second biggest department store chain in Turkey, and it was taken into a phase 2. We preferred not to give a commitment, and ultimately, at the end of the phase 2, the transaction was confirmed. So one has to assume that all cards are still on the table when there's a phase 2. And in phase 1, if you're getting signals that this is going to be a candidate for phase 2, it's more of a one-shot affair. If you wanted to provide a commitment, that commitment goes as a one-shot matter, because the negotiation on any kind of commitment more comfortably happens in phase 2. Next slide, please. So in Nidec Embraco, one of our files, this concerned the acquisition of sole control over the refrigeration compressor business of Whirlpool, that is Embraco, by Nidec. And the board decided to initiate a phase 2 review. The same happened also in the EU. The transaction was approved ultimately pursuant to commitment package submitted to the Commission about the divestment of Nidec's own light commercial compressor and household compressor businesses. And the board concluded that the relevant commitments eliminated the horizontal and vertical overlaps in Turkey. The situation was more complex in the EU, and the files have been handled hand in hand in Turkey and in the EU. Our law firm has represented this transaction vis-à-vis the Turkish Competition Authority, and we have seen that the Turkish Competition Authority in this particular instance did not want to proceed too quickly when the matter is also under review in the EU. This does not mean to say that the Turkish Competition Authority always waits for the decision of the EU Commission, but back in the day, up until 4 or 5 years ago, the Turkish Competition Authority would immediately provide an approval decision to some notifications that then ran into troubles in prominent competition law jurisdictions such as the EU or the US. Now, the Turkish Competition Authority develops a deeper look into the matter, sometimes even in instances where there is not much of a theory of harm or an issue for a substantive analysis in Turkey, which is obviously, in my view, a mistake at the part of the Turkish Competition Authority, as Turkey is not a member state and the Turkish Competition Authority is entirely independent. So, waiting to understand what the theory of harm in the EU is understandable, but when it comes to a point where the parties are waiting just for the sake of waiting, that needs to be eliminated. One should report, though, that this is not very frequently the case, and more than frequently, in those kinds of instances, the approval decision is provided earlier than the approval decision in the EU or in other jurisdictions. An interesting example is Luxottica Essilor, where the merger of Luxottica and Essilor was being in the branded prescription optical frames market and the branded sunglasses market. This transaction was being considered. What makes it interesting is the reverse situation of what I have explained has happened here. So the EU took issue with it, the Turkish Competition Authority took issue with it. The Turkish Competition Authority took the position that while certain commitments given to the European Union Commission seem to cut it as a source of worry in the EU, in Turkey more will be needed, because the theory of harm goes deeper and the dynamics of the market is different in Turkey. So as a structural remedy, the parties proposed to divest Merve Optik in order to eliminate horizontal overlap. In terms of behavioral remedies, it was proposed that the parties and the combined entity would not implement tied sales of ophthalmic lenses and some other products. And the parties and the combined entity would not apply any contractual or de facto exclusivity provisions which prohibit or restrict the opticians from purchasing from their competitors. This last bit was also owed to the fact that there was already an investigation launched into exclusivity practices. Our law firm had defended the relevant party in that investigation as well. So there was an underlining of the fact that the existence of this transaction doesn't change anything in Turkey. And then there were some additional conditions requested as a commitment in Turkey and given by the parties on top of what was given in the EU. This does not mean to say, though, that you need to repeat all of the commitments given in the EU also separately to the file in Turkey, as I will explain with the next slide. This is not the case, and you can actually refer to commitments given in the EU. Next slide, please. So in Bayer Monsanto, which is a notification done by our law firm, the transaction concerned the acquisition of sole control over a Monsanto company by Bayer, and there were horizontal overlap concerns as well as vertically related markets. So the board evaluated Turkey-specific effects of the commitments that were submitted before the Commission. So there came a time where commitments were produced in the EU, and we have submitted that this is submitted to the authority in the EU. The board indicated that the relevant structural remedies eliminates all of the Turkey-specific horizontal and vertical competition law concerns raised by the authority while taking it into the phase 2 review. So the board granted approval to the transaction on the condition that the remedies submitted to the Commission will be implemented. So technically speaking, the parties did not need to repeat the very same commitments to the Turkish authority, but they needed to show that official commitments have been given to the Commission, and the Turkish authority said, if you comply with what you have given to the Commission, and it's on the Commission to pursue that these commitments are actually performed, then I don't have a problem with it either, because it's peripheral effects on Turkey and alleviate all the worries that we have about hindering competition in Turkey. In Arkas Mardaş, this concerned the acquisition of Mardaş that is conducting activities in Ambarlı Port by Limar, which is controlled by Arkas Holding. The board approved the transaction as a result of the phase 2 review with the remedy package comprised of the following. There will have to be an operational unbundling. There will have to be a legal unbundling. Not changing the trade terms, operations, and certain services offered to the current feeder and or deep sea liner customers of Mardaş for 36 months from the date of the share purchase agreement. Not amending Mardaş's standard port services tariff for 12 months, and what have you. Now, this particular file is interesting. It's a file of 2018, mid-2018, because this is a reflex the Turkish Competition Authority uses quite frequently. They sometimes freeze the dynamics of the market for 36 months or 18 months, what have you. We have had the same kind of a debate with them in the Sab Miller, ABI Sab Miller file that we have represented before the Turkish Competition Authority, where a switching behavior of the customers impacted from the transaction is secured by the Turkish Competition Authority. So basically, entries from abroad are plausible, alternative routes of supply are open, but if you close immediately, and if that closing of the transaction immediately changes the dynamics of the transaction in Turkey, the dynamics of the supply in Turkey and the parameters of supply in Turkey, this may harm certain customers in Turkey. So in terms of commitments, the Turkish Competition Authority sometimes concentrates on making sure that the same terms and conditions that were applicable will continue to be applicable for a duration of, in this case, 36 months and 12 months. And then there's also operational unbundling and legal unbundling, which is quite draconian as structural remedies. And this is to make sure that there is no undue exchange of commercially sensitive data and that there is an arm's length dealing in the marketplace, which rarely comes into gameplay in Turkey as a commitment type as well. Next slide, please. Now, in terms of the merger control trends, I have explained to you certain files. I don't mean to go into the details of all of the particular files that the Turkish Competition Authority deal with, but you need to know that there are recent amendments to the legislation that needs to be covered in the scope of this presentation. Next slide, please. So the new amendment to the legislation, which is very new, a matter of last summer only, only 6 months that it has been applicable, it brings de minimis principle for agreements, concerted practices, and decisions of associations of undertakings. It brings the SIEC test for mergers and acquisitions. It brings behavioral and structural remedies for anti-competitive conduct. It brings the commitments and settlement mechanism. It provides clarification on the powers of the authority in downgrade situations, and clarifications on the self-assessment procedure in the individual exemption mechanism. I wanted to give you a broad overview of what it does, although not all of them relate to merger control. But one bit that relates to merger control is the SIEC test. Next slide, please. I'm not going to go into the details of the SIEC test, as this is a crowd that is knowledgeable about competition law in general, and they want to know about the newer trends in merger control in Turkey. But just know that now we're using the significant impediment of effective competition. So this is saving the Turkish Competition Board from those cases where sometimes when they saw a plausible theory of harm and wanted to take a matter into phase 2, they feared that the administrative courts would say, I don't see a high concentration ratio or a significant delta or a high resulting market share post-transaction. Why did you take it into a phase 2? Now, with the significant impediment of effective competition test, it is easier for the Turkish Competition Authority to articulate its theories of harm in instances where this is not apparent through the market power parameters, but it is rather a function of unilateral effects or cooperation effects that they want to more sophisticatedly articulate in their decision. Next slide, please. One very, very interesting bit that you may want to note and remember about Turkey is, unlike most other jurisdictions and the EU jurisdiction, in Turkey, if the Turkish Competition Authority is going to push structural remedies, these structural remedies necessarily have to be tested after behavioral remedies. So the Turkish Competition Authority does not have the authority to push structural remedies unless it has tried and failed with behavioral remedies. And what we mean to say, or rather what the legislation means to say, is not that it should be offered, it is that that kind of a condition should be first imposed, and upon that failing, only then you can move on to structural remedies. One thing that is very frequently misunderstood, even by specialist local counsel in Turkey about this new legislation, is that this does not hinder, it does not hinder the ability of the applying parties, the local council, to provide structural remedies from the get-go. So while the Turkish Competition Authority cannot ex officio impose structural remedies if it has not tested the viability of behavioral remedies first, this does not bind the applying parties in terms of their ability to provide directly and initially as an opening gambit these structural remedies. The structural remedies can be the first resort that they go to, and the Turkish Competition Authority wouldn't be able to say, without you testing behavioral remedies, I'm unable to accept a commitment on structural remedies. So this legislation does not tie the hands of the local council and the applying parties in terms of formulating the type of structural remedy that they want to formulate if they believe that the behavioral remedy is just going to be a loss of time, because it's not going to be effective, and ultimately it's not going to secure the legal certainty around the transaction. Next slide, please. This I have explained, so we can switch to the next slide. Gun jumping issues are interesting in Turkey. I'm going to speak to you a little bit about gun jumping issues. I have about 10 more minutes to cover, and then if there are any questions, I'm happy to respond. Otherwise, I'm happy to call it a day as well if it has been satisfactory for you. But most importantly, I have two topics, one of which is gun jumping issues. The Turkish Competition Authority has been quite keen on the gun jumping matters. This has been an issue of particular interest because there have been quite a bit of complaints in Turkey about whether a de facto change in control has happened. The Turkish Competition Authority has looked into whether any business activities that could enable the undertaking concerned to emerge in the market as gun jumping has happened. Exchange of commercially sensitive information has been seen as gun jumping. Actions or recommendations on employees and managers has seen as a form of gun jumping. Not all kinds of recommendations, obviously, but if particularly HR steps have been taken and integration steps have been taken, then the Turkish Competition Authority has taken the view that this is seen as a method of gun jumping. Provision of certain types of trainings, especially when they render transparent the particular sensitive information, commercial sensitive information, this has been seen as a matter of gun jumping. And establishing joint marketing and working teams also has been a matter of gun jumping. Next slide, please. The gun jumping matter, one of our matters was very interesting. This is the Boyner YKM. I'm bringing it from 2012 because while there have been newer developments, this particularly has been the seminal case that deals with gun jumping issues. The board evaluated here whether the parties had actually implemented the transaction prior to the approval of the board by examining the following matters. We have defended the notifying party. This is the same transaction that fell into a phase 2, and then ultimately we obtained the approval decision. And during that time, there was also a separate administrative procedure proceeding on whether gun jumping has happened. And this was cancellation of orders of the target entity, integration of organizational structures between the stores, obtaining of resumes of the other parties' employees and executives, dismissal of other parties' employees, the target refraining from renting a store in an area where the acquirer and the target competed with each other, the acquirer informing shopping malls about the acquisition and requesting from them oral commitments to change store signboards and all that. So some of these were actually preparatory steps for a closing, and some of these were more borderline. Ultimately, we managed to defend the client, but this has served ever since as a very borderline and sensitive case of gun jumping allegations, and it gives you an idea as to how sensitive the Turkish Competition Authority can be on gun jumping issues. The violation of suspension requirement matter is a completely different matter. There, the Turkish Competition Authority is extremely rigid. So they do not look into the intent, they do not look into the results, they do not look into whether there has been a particular effect of that amalgamation in the country, but if the closing has taken place and if this was a notifiable transaction, suspension requirement has been violated, and I'm giving you your administrative monetary fine, and the transaction is rendered null and void until I approved the transaction on a later date. Next slide, please. In Agence Presse, the board found another gun jumping file that Agence Presse actually controlled PRNet for a certain period of time before the share transfer. So PRNet apparently moved to the building where Agence Presse was seated. Agence Presse intervened in matters such as choosing PRNet's telephone numbers and broadcast subscriptions. PRNet network worked with Agence Presse's network. PRNet personnel had a meeting at a specific time upon the direction of the owner of Agence Presse. Shared customer lists had been prepared and joint studies had been arranged, and production sources have been shared. Now, as you can see, the type of analysis that the Turkish Competition Authority does to see if there has been an instance of gun jumping or not is not a boilerplate analysis. When you compare and contrast these findings with what has been looked into in the YKM Boyner matter, we're looking into different matters. If you were to cherry pick one of these, not a singular one would amount to an act of gun jumping in and of itself. Well, maybe with the exception of shared customer lists, that could in and of itself carry the matter above a threshold of gun jumping. But it seems the Turkish Competition Authority is looking into a totality of circumstances kind of an analysis, and that is the impression we're trying to create with giving this example to you. Next slide, please. As I said, the suspension requirement is very rigid in Turkey, and the sanctions are enforced very directly without much of a question being asked about whether the intention of the parties was to violate the suspension requirement or whether there was any harm anyway. Next slide, please. So there is an administrative monetary fine that goes to 0.1% of the acquirer's Turkish turnover. If it's a joint venture transaction, obviously this will fall upon both parties, and if it's a merger of equals, it's going to fall upon both parties. But in an acquisition transaction, the party that has to do the notification is the acquirer, and because the positive duty is falling upon the acquirer, the administrative monetary fine would also fall on the acquirer. The 0.1% is the Turkish turnover, including exports of the acquirer. Next slide, please. This is not up to 0.1%, by the way. This is directly 0.1%. What is up to is up to 10% of turnover if after review of the transaction which violates the suspension requirement, if the Turkish Competition Authority says, had this been notified to me, I would not have approved this transaction. In that case, the Turkish Competition Authority goes for up to 10% of the turnover of the parties, in which case the members of the executive bodies and employees of the targets could be subject to fines of up to 5% of the fine imposed on the undertaking. For example, if the Turkish Competition Authority comes up with 3% of the Turkish turnover of the acquirer for realizing a transaction that is actually failing under the SIG test, so there is a rejection decision, but it has been realized in the country as well, then that 3% will be given to the company because it is up to 10%, and in the hypothetical that we have, the Turkish Competition Authority has chosen to give 3%, subject to the secondary legislation governing that calculation. And then 5% of that 3% could be given to, say, the CEO or whoever was driving the transaction, whoever is caught red-handed in implementing a transaction that is notifiable and that is now rejected in Turkey. Next slide, please. So there is also a legal consequence that the transaction is deemed to be null and void until an approval decision is given. So you cannot rely on the legal existence of that transaction until an approval decision is given in Turkey. So apart from the administrative monetary fine, you're also looking at a legal consequence problem. Next slide, please. This is an interesting new case of July 2020. We have represented, as a law firm, we have represented BMW, Daimler, Ford, Porsche in this transaction. The parties took advice from us as to whether the joint venture is notifiable in Turkey. We said this joint venture is notifiable in Turkey. They were accepting in a fifth player into the joint venture. And then we said, oh, and by the way, at the point in time when you formed this joint venture back in 2017, among the four of you, it was notifiable back then as well. Apparently, these parties had obtained a legal advice that said this is not notifiable back in 2017. So they had relied on that legal advice and no notification was made. But when the fifth player was coming into the joint control mix, they asked us, and we said not only is this transaction notifiable, but the transaction that you came up with in 2017 was also notifiable. So when we notify this transaction now, it is highly likely that the Turkish Competition Authority is going to look into the failure to notify the 2017 notification, and there would be an administrative monetary fine applicable to that. Our mission is going to be to make sure that it is understood that there is no malintention here, that the parties have always been law-abiding, and also to make sure that the review period of your new transaction, which is accepting the fifth player into the joint venture mix, is not extended unduly, because typically what happens is your notification gets parked and a wholly new question and answer session starts on the basis of the very first notification that should have been made. Then that gets reviewed, then that gets approved. Now I can build on that transaction. So what were you saying about the new transaction you wanted to do? Oh yeah, so let's look into this. And before you know it, you might be looking at 120 days of review time on the new transaction that you wanted to do. So in order to avoid that, we have carefully crafted a notification, and we have worked with counsel for the fifth entity that was coming in to the joint venture mix. So we were representing BMW, Daimler, Ford, and Porsche, but the fifth player coming in was represented by another law firm. And we made sure that one, there is no undue delay because we're not being transparent. So we wanted to give all the information up front. And also we wanted to make sure that mistakenly the fifth entity is not included in the mix of entities that get an administrative monetary fine. Ultimately, the Turkish Competition Authority has taken the view that in 2017, the BMW, Daimler, Ford, Porsche transaction should have been notified. So here is your procedural administrative monetary fine, but no harm done. This is your green light for that transaction, and this is the green light for the other transaction. That brings the number of joint controlling parties from 4 to 5. Next slide, please. One thing that is important to see, and I'm wrapping up this session with these last remarks, is that typically the Turkish Competition Authority imposes administrative monetary fines in instances where there is a violation of the suspension violation. So defenses that go into intent, defenses that go into effect, defenses that go into the transaction structure being complex and therefore them not exactly understanding the point in time where the notification needed to be made and all that, these are not heard. Ersoy Sesli Anayurt is one of those examples where the parties tried to explain that this seemed like a back-to-back transaction to them, so they intended to do their notification at the end of the second transaction, and that's why the appearance that there is a suspension violation about the first one has happened, so no need for an administrative monetary fine. The Turkish Competition Authority has said, I don't agree with this. This is not technically a tied transaction. I have my governing principles about tied transactions, which is, by the way, as a side note, very close to the principles applicable in the EU for the same matter. So seeing that this is a standalone notifiable transaction that was not notified, your confusion as to the character of the transaction doesn't have a bearing on my analysis. Here's your administrative monetary fine. Next slide, please. There's an 8 years of statute of limitations on suspension requirement violations. Next slide, please. I have already explained this, so I'm not going to place more emphasis on it. The JV transactions with no local nexus are notifiable in Turkey. I'm going to give you a few examples of this, which is very important, I believe, all around the world, because any kind of joint venture will need to be tested for the turnover of its parties in Turkey, and if it is exceeded, regardless of how remote the joint venture is in its operations to Turkey, still the notification will need to be made, be it a joint venture for railroad pavement in Siberia, be it a joint venture for mining in Chile, be it a joint venture for local consumption of a specialty energy product in a part of Brazil. Whatever the purpose of the joint venture may be, if the parties to the joint venture are operational in Turkey, and if their operations exceed the thresholds, that joint venture will be notifiable in Turkey. And this is not some very textbook-driven, rigid attorney giving this advice. Actually, we have fought tooth and nail that these transactions should not be notifiable in Turkey, but now it is inescapably clear with tens of decisions of the Turkish Competition Authority that these transactions are seen as notifiable. The absence of notification in these kinds of joint ventures where there is no apparent local nexus attract suspension requirement violation fines, and the Turkish Competition Authority doesn't even rubber stamp these kinds of notifications, but they do ask questions about overlaps and the structural link between the parties. Next slide, please. Mitsubishi Corporation Wallenius is an example of this. The transaction concerned the creation of a full-function joint venture for inland vehicle logistics services in Thailand. And it was not expected to be active in Turkey. But in January 2020, this was seen notifiable and an approval decision was given. In Generali Union Zaragoza Properties, the joint venture did not have any Turkey-related activities and was not in a position to enter the Turkish market in the future. Nevertheless, the transaction was notified to the authority and approved by the board, February 2020. Another example from January 2020, FSI OLT Offshore, it was virtually impossible for the joint venture to enter into the Turkish market in the future, given that the entirety of its activities were based on an immobile carrier off the coast of Livorno, Italy. Nonetheless, the transaction still required a mandatory merger control filing before the authority, and it was approved by the board. Now, you may think, which was what we thought many years ago, that if you notify this transaction, of course you're going to get an approval decision. But this does not mean that the Turkish Competition Authority really wants to see these transactions. It's just that it is an unnecessarily deep analysis for them that is uncalled for the purposes of the analysis at hand. So when you notify, they look at it and they don't see an issue, so they give an approval decision. But the fact that they haven't given a negative clearance decision, i.e. a decision that says this wasn't notifiable in Turkey to begin with anyway, but rather an approval decision, cannot be read to say that they are willfully asserting their jurisdiction over these transactions. This, for a while, many years ago, we have thought about. But over time, the Turkish Competition Authority has come up with a very robust body of reasoned decisions that develop a theory as to why there is effect in Turkish soil, that effect being the structural link between the joint venture parties. And while a substantive analysis of the transaction cannot lead to a rejection decision, it still holds to be true that these transactions need to be notified in Turkey. Next slide, please. The same thing, the same rigid approach also happens about the submission of false and misleading information to the Turkish Competition Authority. You need to remember that the Turkish Competition Authority is quite rigid when it comes to characterizing something as misleading information. And what incentive could I have had to provide a misleading information about this point? Cannot be a sufficient defense. Or the fact that such misleading information could not even have a relevant impact on the analysis. It wasn't germane to the finding, these kinds of things, or I didn't have any intent to provide misleading information. These do not have a bearing on the analysis. So the Turkish Competition Authority acts quite procedurally when it comes to administrative monetary fines of procedural nature. Next slide, please. In Brookfield Johnson Controls, the board imposed 2 separate administrative monetary fines of 0.1% of the annual turnover of Brookfield for gun jumping and for providing false and misleading information. In OMV Petrol, the board emphasized that the intention to mislead the authority is not a criteria for a violation of the relevant legislation, which rejects submission of misleading information. So if I see an information and if it is incorrect, I'm going to apply the 0.1% administrative monetary fine is what they said. With that, I conclude my remarks. Next slide, please. And of course, I am happy to respond to any questions you might have via email, by phone. I see that we haven't received any questions at this point. Let me check one more time. Oh, hang on. Sorry, this is my mistake. So there is one question. The SEEK test. What are your initial thoughts about the possible future applications of the SEEK test by the TCA? Pros, cons, will it be effectively applied by the TCA? I don't see any reason why it wouldn't be applied effectively by the Turkish Competition Authority. There is enough case law in the EU as to what the SEEK test brings. Of course, it's a looser analysis, so hopefully the Turkish Competition Authority is not going to resort to speculative theories of harm or scaremongering, but hopefully they're going to use the SEEK test in its technical capacity. Otherwise, it would not be fruitful, and some perverse enforcement in competition law might be seen. But in general terms, I don't suspect that this is going to lead to the Turkish Competition Authority reinventing the wheel, really. So it's just enabling the authority in certain instances where they were stuck between the market parameters available to them and some plausible theories of harm that they could have articulated if they were not demanded to show a significant increase in market power from the get-go. So the SEEK test from that angle might be fruitful. Again, with apologies for going 10 minutes over, I hope this was a useful session for you, and I am happy to respond to, and our law firm is happy to respond to any question that you might have on Turkish competition law matters, of course, Turkish merger control matters. Thank you very much for your patience.